introduce yourself?
Yes, sir. So my name is Bhavya Phuleta. I was born and brought up in Delhi. I completed my schooling from Delhi in 2015. Thereafter, I joined National Law University, Delhi, and completed my BA LLB honors in the year 2020. I worked with EY for about 10 months in their legal contract drafting team, and then I quit my job to prepare for judicial services. I recently also completed my master's from National Law University, Delhi in 2024.
What about your parents and siblings?
I have one younger brother. He is currently aiming to pursue MBA. My father is a businessman. He has his business in Karol Bagh in Delhi. My mother is a nutritionist and lifestyle coach.
Okay. Bhavya, you have done masters also. You have registered yourself. What was the specialization in your masters?
Sir, at National Law University, Delhi, there were two options. Either masters could be done in public laws or commercial laws. So I opted for public laws. And in public laws, it was up to the students to select any of the optional subjects for each of the 2 semesters that were there.
Mm-hmm. So why you feel that you shall be a judicial officer?
Sir, as a law student, I was very inspired by the court proceedings and the environment of the court. And I was always in awe looking at the position of a judge in the courtroom. So
Mhm.
it was so inspiring that I wanted to build a career for myself in this field.
You just said that in EY you worked and you were looking after for contracts.
Yes, sir.
Isn't it? What are the essential elements of valid contract?
Sir, for a contract to be legally enforceable, there should be some the contract should not be against public policy. It should be for some legal purpose. There should be some consideration. The contract must be an agreement between two parties who have their individual parts to be performed in a contract. The essentials of a valid contract are provided under Section 10 of Indian Contract Act.
Whether a minor can enter into a contract.
No, sir. Minor is not permitted to enter into a contract because under Indian Contract Act, it is believed that minor is not legally capable to enter into binding contracts, which,
You talked about a legal contract. What is illegal contract?
sir, sir, I don't think illegal contract as a term exists. But in an attempt to answer your question, I believe that any agreement having an unlawful or illegal or immoral against to public policy, any purpose like that would be illegal agreement and it would not be enforceable as a contract.
You just said there is nothing like illegal contract, but you're telling that
Uh,
illegal.
yeah, sorry, sir, that was the wrong phrase on my end.
No
Contract by
issue.
its very nature is an agreement enforceable by law, so that way no illegal
No,
contract can
no
exist.
issue. No issue. Can you just tell me regarding the what are the differences between the first appeal, second appeal, and revision?
Under Code of Civil Procedure.
Yeah, it is general.
So, first appeal under Code of Civil Procedure has been provided under Section 96. Section 96 states that every order or every judgment otherwise it will not be appealable. And it can be appealed on the basis of both question of law and facts. Second appeal is provided under Section 100 of Code of Civil Procedure. However, second appeal can only be undertaken on a substantial question of law and not on a question of fact. Second appeal usually lies before the High Court of a state, and revision is an remedy available under the Code of Civil Procedure, whereby parties can request the court that has already given the order to relook into the judgment that has been given and redecide the issue.
Okay. What is the role does judiciary play in protecting the fundamental rights?
Sir, judiciary has been called to be the protector of fundamental rights in India. It is the apex authority uh, that can enforce the fundamental rights for citizens. And Article 32 of the Indian Constitution empowers the Supreme Court to directly hear citizens by way of writs on the question whether their fundamental rights have been violated. And a similar right has been provided to high courts under Article 226.
Okay. Recently, there was some Supreme Court judgment on protecting the under PMLA Act. Do you
Yes,
have
sir.
any idea?
Sir, regarding bail under PMLA, Abhishek Banerjee, if I'm not wrong.
What is
Sir, in
precisely what is that?
sir, in that case, as far as I can recall, Abhishek Banerjee and his wife were requesting the transfer of proceedings from Delhi High Court to their home state, and Supreme Court said that PMLA has complete jurisdiction to take the undertake the proceedings at Delhi itself because the cause of action has arisen in Delhi. And the second question was on the matter of bail, and uh, I'm sorry, I cannot recall what was the final judgment of Supreme Court
Right,
on that
right,
question.
right. Being a judge, when you are appointed as a judge, what do you feel that how the pendency of cases can be reduced?
Sir, I believe the Indian laws and guidelines given by higher judiciary in this regard are quite self-sufficient, and there are procedural guides to be followed at every step of a proceeding or suit. So, as a judicial officer, I believe that I will dedicatedly stick to the timelines. I'll follow the procedure. I think that should be helpful in itself.
See, in many cases, the timeline has been framed also by the parliament itself. But even in those cases also, those type of matters also, the timeline is not being adhered to. Even in POSCO cases, even in civil matters, even in recovery matters, the timelines have been given. But do you have any idea that how many cases are pending throughout India?
So the number is in lakhs. I cannot recall the exact number right now.
Number is in
Before the Supreme Court only, or
total. Total.
so the number is in lakhs for
Okay.
all pending cases before judiciary.
Okay. Saket. So
Hello, Bhavya.
Hello, sir.
Uh, so, how was your experience in working with EY?
Sir, I was preparing for judicial services during my college days also, but because my peers were all targeting corporate jobs, so just to experience a corporate job for myself, I decided to sit for the interview and I worked with EY for 10 months. I personally did not feel very satisfied. However, the learning curve was very high for me. I learned a lot of things. So
But
overall, it was,
since you were preparing for judiciary during your college time and
yes,
subsequently
sir.
you went for a job, should I consider that, should I conclude that you were not ambitious enough to go after your goal of becoming a judge?
Sir, I don't think that directly translates to not being ambitious. I think at that time I was just 23 and I wanted to see what all things I can do in life. I was looking at different aspects in life. I was already preparing for judicial services, and after getting that little experience of 10 months, I decided that this will not give me long-term satisfaction. So I went to preparing full time.
Okay. ADR mechanism, alternate dispute resolution. What is the basic provision that governs this? From where this, if I talk about CPC, is there any particular section that governs this?
So Section 89 provides for ADR mechanism, and it states that if a matter reaches before a civil court, and if a matter is of such nature that it may be resolved by alternate dispute resolution, then the court may refer the parties for resolution by means of arbitration, conciliation.
Tell me, Bhavya, do you think arbitration has served its true purpose in our country?
So overall, I think arbitration has been quite beneficial because after the implementation of Arbitration and Conciliation Act, both the previous version and the after the revisions recently, the commercial arbitration in India has upscaled a lot, and many companies are now able to resolve their disputes in India effectively, quickly, and many corporates are willingly following arbitration-based resolution rather than resorting to courts.
So, can you explain it to me, the pecuniary jurisdiction? What do you mean by that?
Yes, sir. Pecuniary jurisdiction, I think, is given under Section 6 of the Code of Civil Procedure, if I'm not wrong. It states that uh, 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 any case which is filed before the civil court should be according to the monetary lowest pecuniary limit.
Just
Uh,
give an example with respect to Delhi.
Sir, I'm not sure what the amounts are in Delhi, but I'll give an example. For example, the three levels of civil courts are there. One handles cases up to 2 lakhs, another, the next level handles up to 2 to 10 lakhs, and the senior level handles above 10 lakhs. So if the matter of the suit is 5 lakhs, then it should go to the second level.
So, are you aware about the pecuniary jurisdiction of High Court of Delhi?
I'm sorry, sir, I'll read and check that. Currently, I'm not.
Okay. Bhavya, in general, as we see, there are so many, women that are opting for judiciary, but on the same side, there are not very women who are, enthusiastically pursuing litigation career. So, I'm talking about core litigation. So, why is it
Yes,
so?
sir.
I mean, will you fall in the same category? Because if you don't want, like, that you don't want to practice litigation, that is why you want to opt for judiciary?
Sir, I could not practice litigation due to personal reasons. However, I'm very fascinated by litigation as a profession. If I could have, I sincerely believe I would have. And my considering my peers, I think this generation women lawyers do get into the profession of litigation, and they are sincerely practicing before courts. And I personally know a lot of friends who are doing that. So maybe in the earlier times, it was tough for a female to grow as a lawyer in India. But even now, there are senior advocates who are female. So I think overall, females do participate in litigation. Uh,
Okay. That's
it's
okay.
competitive only.
Yeah.
Yes, sir.
So, with the new law, we have now Bharatiya Nagrik Suraksha Sanhita,
Yes, sir.
BNSS, which is the replacement for CRPC.
Yes, sir.
You see the name, it's Criminal Procedure Code, right? Which
Yes, sir.
entails the procedure, how a case will travel through from the beginning to the end, right? What is the procedure involved? Now they have given it as a name Nagrik Suraksha.
Yes, sir.
How Nagrik Suraksha is relevant here?
So, a lot of provisions given under the Bharatiya Nagrik Suraksha Sanhita, they deal with the protection of citizens who come in contact with law enforcement authorities. For example, the bail provisions or arrest provisions and other criminal procedure related provisions. So many of those are targeted to balance the rights of an individual with the requirements before law, which is why I believe the term Nagrik Suraksha has been used in the name of this act.
But don't you think procedural part is more dominant?
Sir, the procedural part is dominant certainly when number of sections are considered, but the intent of this legislation is uh, to balance the rights and protection of individuals with that of safeguarding the interests of society under which offenders are punished. So ultimately, I
Uh, do you see
balance these interests only and protection of individuals.
interpretation as a
So my earphones are off. I'm so
yeah,
sorry.
sure, please?
Sorry about that. I
Uh,
dropped my earphone.
do you see interpretation as a challenge when it comes to contracts?
Interpretation. Sir, at times it can be a challenge. This is because of the reason that not every party who is entering into a contract may not be well versed with legal terminology or complicated provisions that are sometimes drafted into the contracts. So, in that sense, interpretation can become tricky, and parties are also sometimes at risk that way.
And do you see that as a, I mean, major challenge, that acts as a sort of hindrance in arbitration regime? Because that also essentially a lot of litigation involves around interpretation of that particular arbitration clause.
Sir, I have very limited experience, but I believe that must be the
That's okay.
case.
That's okay. So they say execution proceedings in our country is akin to filing of a new case, right? So let's suppose firstly I file a case, after so many years I get a favorable decree in my favor, and then now I will have to go for execution, either to get my money back or whatever it is. So the execution also is going to take the same time that is being taken in original case. So how to address this issue?
Uh, Sir, many safeguards are now inbuilt in the Code of Civil Procedure. For example, bar as to jurisdiction should be taken up at the first instance, which has been provided and enforced under Section 21A of the Code of Civil Procedure by way of amendment. And similarly, other objections such as objection to the preliminary decree should be taken up at the first instance. There are provisions and safeguards against that, but sometimes, even so, at the time of execution, some questions may be taken up by parties, and the court may decide to look into those decisions to ensure that the decree is enforced in a judicious and effective manner. Uh, in order to do justice. So sometimes delay is inevitable, but mostly it has been provided by the provisions of Code of Criminal Civil Procedure. Sorry.
Okay. Bhavya, let's imagine a situation where you are, presiding a court, and there is many lawyers, both on both sides. So one side is pressing that the matter needs to be argued today only. Okay, they wanted some interim relief at the earliest, and the other side is saying, they want an adjournment for say 2 days, but the fact of the matter is they've already taken 2, 3 adjournments, right? So they might have some reason that senior counsel is not there or whatever it is, but the other side is stressing the matter should be heard today only, and the one side is saying they want adjournment. So how are you going to address that?
Sir, in CPC, there's a provision that states that only three adjournments can be taken by a party to a suit. And if already two
Do
adjournments
you,
have been
do you think that is being followed in the courts?
sir, not uh, properly, because sometimes uh, the issues are serious and adjournments may be sought on genuine grounds, and civil court has a duty to ensure that no party is harmed by matter of procedures. So, but ideally, three adjournments should be given to a party, and if that party has already taken adjournments before, so I think I will incline towards
Okay.
looking into what remedy the other party is seeking.
Can you, with respect to PMLA, can you tell me the difference between a scheduled offense and predicate offense?
I'm sorry, sir. I'll read more on this. I'm not
That's
aware.
okay. While replying to sir, also you were talking about some transfer of case. So let's suppose if I have to seek a transfer of a case pending in matrimonial court in UP to a matrimonial court in West Bengal. So which court should I approach?
Supreme Court, sir, under
Any,
Section 25 of CPC.
and if it's a criminal case?
Sir, even then, I think Supreme Court, but I am not sure, much sure for criminal case. There was a case by Supreme Court in which Supreme Court laid down that High Court of a state has no authority to transfer a case pending before a subordinate court to it to a subordinate court under another High Court. So, following that judgment, I think Supreme Court only should have proper authority.
Okay. What are your views about All India Judicial Service? Has it,
Uh,
has it been provided in the Constitution?
Sir, it was provided by 2015 Amendment Bill, but it became an act, but it was struck down by Supreme Court in 2015.
No,
Uh,
no.
in,
I'm not talking about NJAC. I'm talking
yes, sir.
about All India Judicial Service.
Okay, sir. Sorry, sir. My bad.
That's okay.
All India Judicial Services, I think it has been provided in the Constitution that if the need arises, then Parliament can provide for All India Judicial Services. But it has both pros and cons. Currently, all states are able to look for candidates that best suit the requirements for their particular state. But if the process is made uniform, then that liberty of states to select only candidates knowing a certain language, for example, or checking knowledge of certain local laws, etc., would be taken away. So that is definitely a con. However, if it is implemented, then it would streamline the process. It would become uniform. Annual exams, an annual examination cycle would come into place. So it has both pros and cons, I think, sir.
Okay, my last question to you. Uh, Under the new law, offense of sedition has been done away with, right?
Yes, sir.
But there are other offenses which uses the same subjective languages. If I give you an example, saying acts endangering sovereignty, unity, and integrity of India,
Yes, sir.
you see, it will be even more problematic when it comes to the interpretation of such offenses.
So the intention behind the change in this language was that any hatred or feeling of discontent which was earlier there against the government would no longer be an offense because the actions by a government can now be freely criticized in a fair and public manner, however way citizens want to do. At the same time, there are certain acts which jeopardize the interests of the nationality and sovereignty of India as a country. So only those offenses would now, those acts would now be looked at as offenses.
All right, my last question. So if it's beyond reasonable doubt in criminal law, what is the same phrase in civil law?
Uh, Preponderance of probabilities.
Thank you.
Thank you, sir.
Bhavya, I want, shall I, shall I take the question?
Yes, yes, sir.
No, I'm
Yeah.
asking Saket.
Okay.
No, sir. So we have 5 minutes. You can have a
Ah,
question and then we can give the feedback.
no, I will just I want to, in one question, there are two questions. That is, one is that what is the preliminary injunction, and or stay? What are the difference? And second part of the question is, what is the difference between decree and order?
Sir, I'm sorry, I could not get the first word from first part of your question. Which injunction, sir?
First is preliminary injunction,
Preliminary.
and
Okay.
stay. What
Okay.
are the difference between all these three, and what is the difference between order and decree?
The preliminary injunction, uh, I am not very certain, but if I may make a reasoned estimation, preliminary injunction would be something, a, a remedy of injunction which is passed by civil court during the initial stages of the suit. And the matters are yet to be decided, but the object would be to stop the party from acting in a manner which is prejudicial to the interest of other party. So I think that would be preliminary injunction. Stay would be, I think, in
After that, what is the injunction? First is in preliminary, then is injunction, and then is stay.
okay, okay, preliminary, only preliminary, not injunction. I'm
Both,
sorry, sir.
both. Okay, no, if you are telling about order, okay.
Yes, sir. I think I'm not able to understand the question, sir. Would you please
So my
explain it to
question
me?
is very simple. What is preliminary injunction? Then what is injunction and what is stay?
Okay. So preliminary injunction,
Um,
okay. Preliminary injunction would be passed during the initial stages of the suit in order to preclude the party from acting in a manner prejudicial to the interests of other party. Injunction um can be mandatory or temporary, and it can be perpetual um, or prohibitory also. There are four types of injunctions that way. So I think preliminary injunction is one of the subcategories of injunction. And then stay would be more of a perpetual nature of injunction. That would be to prohibit a certain party from acting in a particular manner until the court further allows the party to do that. So that would be permanent stay.
and what is the difference between decree and order?
The order can be any formal pronouncement by the civil court during the suit. It can be multiple in number, and multiple orders can be given in a civil suit relating to different issues at hand. And decree can be preliminary also, but the final decree comes after the judgment when the suit has been finally decided. So decree would be the summarization of the actionable part for both the parties at the end after the judgment has been delivered by the court.
Okay. One last question I would like to ask you is regarding that recently Kolkata that case, rape and murder case.
Yes,
The
sir.
whatever judgment has been passed, do you agree with that, or if you were the judge, what judgment you should have been or you would have been given?
Sir, the matter that was before the court was of very sensitive nature, and the offense which had been committed was quite serious. And um I think I'm too small to agree or disagree with the judgment of Supreme
No,
Court
if
in
you
that
were the
matter.
judge, what judgment you would have?
Sir, I think I would follow the same decision that has been given by Supreme Court that even though the offense is very grave and serious, it would not fall under the rarest of rare categories, and death penalty would not be invited in this circumstance, in this particular case.
No, the order of the judge says that it is a rarest of the rare case. You are telling it is not. but he has not given he has given life imprisonment. So
Yes,
my
sir.
question is whether you will agree with, because he himself in order says that it is rarest of rare case.
Sorry, sir, for that wrong knowledge. Sir, I would say that death penalty would not be invited for the offense. I would also sentence life imprisonment to the accused in this case.
Okay,
Thank you, sir.
thank you.